Court has reserved ruling indefinitely on the matter brought before it by the Independent National Electoral Commission, challenging the ruling of the Appeal Court on term of office of the governors of Adamawa, Bayelsa, Cross River, Kogi and Sokoto states. Chief Justice of Nigeria, Justice Dahiru Mustafa, adjourned the case to what he says is the nearest future, which will be announced to the parties in the case. The court is to determine if the oath of office is relevant for the determination of the tenure of the governors. It is also to make a pronouncement as to whether the 2010 amendment of Section 180 of the Constitution and the Electoral Act has any retrospective effect on the tenure of the governors since they were sworn in 2008 following the annulment of their various elections prior to the amendment of the Constitution.
Hearing in the matter spanned over 6 hours as all the counsels in the matter were allowed to put forth their argument and adopt their briefs. The counsel to the governors of Adamawa, Bayelsa, Cross River, Kogi and Sokoto states and that of the People's Democratic Party urged the court to dismiss the appeal on the grounds that prior to the amendment of Section 180 of the Constitution, the law recognized that whatever had happened before the election of the governors was annulled are a nullity, and as such their tenure will count from the time they took their fresh oath of office, having won their rerun elections.
An annulled election has no force of law. The court should reckon with the election that took place after a properly conducted exercise, not the one which the court has declared null and void and struck down. The concept of nullity means that it is ab initio. It is null and void, and that it is null from the date when the election was conducted.
Counsel to the Independent National Electoral Commission and the governorship candidate for the Congress for Progressive Change in Adamawa State, General Buba Marwa, however urged the court to uphold the appeal. They submitted that in line with Section 180 of the Constitution prior to its amendment, that what was annulled was the election that brought the governors to office and not their oath of office. They are of the view that the term of the office of the governors should count from the first oath of office as prescribed by the amended Constitution.
The amendment to the Constitution says that where there is rerun election and the same person emerges as winner, then the period he has spent in office would be taken into account in computing the tenure of that particular person. Now, our position is that that has always been the provision of the Constitution in Section 180. And the purpose of the amendment was simply to clarify that, and it's not indeed a new thing. So that is the contention, and we're hoping that the court will agree with us.
The three friends of the court chosen to advise the court on the matter have disagreed on the position they want the court to take. While Mr. Richard Akinjide supported the position of the 5 governors that their term of office ought to start from when they took fresh oath of office, the other 2, Professor Issa Sage and Ajayi Joseph, argued otherwise. Only time will tell what position the court will take following the arguments in court. Amaka Mwajugu, Channels Television News.